claimant following the wrongful termination of the claimant's employment by the defendant. The claimant's case is that she was employed by the defendant bank on the 25th of August 2007 and confirmed in December 2009 after probation and worked at various branches. Following her marriage, she changed her name. On the 2nd of September 2013, she was summoned to the head office, questioned without prior notice over an alleged fraud involving a colleague, and asked to write a statement concerning the issue. That same evening, alongside with a colleague, she was arrested without proper investigation or fair hearing, detained at the Koyi police station, and later arraigned before the Igbo Chief Magistrate Court. Unable to meet bail conditions immediately, she was remanded at Krikri prison with a 6-month-old baby until her release on the 9th of September 2013. She further asserts that the disciplinary council, committee, or investigative team referred to by the defendant are essentially the same body. On the 19th of November 2013, while criminal proceedings were ongoing, the defendant terminated her employment. She remained on trial for over 5 years until she was discharged and acquitted on 28th of January 2019. The claimant alleges that the defendant failed to properly investigate the matter or follow its disciplinary procedure, thereby damaging her reputation and career. Although the defendant later indicated her net benefits in a 2018 letter, it allegedly failed to address a promotion or salary review. After forwarding the CTC of an acquittal judgment to the defendant in January 2020, she received no response. Since her arrest in September 2013, the claimant states she has remained unemployed. The claimant denies involvement in any fraud, conspiracy, stealing, or forgery, emphasizing that there was no eyewitness or expert evidence against her. She contests that the employment was wrongfully terminated without due process and without the proper in-house investigation, despite the previously unblemished record. She disputes the defendant's reliance on provisions of the handbook and rejects the stated terminal benefit of 145.508 thousand naira as inadequate and tentative. She argues that she was denied fair hearing, that the defendant acted carelessly and unjustly, and that several paragraphs of the defense offend procedural rules. Finally, the claimant issued a notice to produce the defendant's detailed disciplinary policy and sanctions grid at trial. At trial, the following documents were tendered through the claimant, and same were admitted and marked as Exhibit C1 to Exhibit C11. I'm not going to list all that is in the body of the judgment. So now the defendant's case. The defendant, on the other hand, maintains that the termination was lawful and conducted in accordance with the internal bank policies and the contract of service. UBA admitted that the claimant was at the head office on the 2nd of September and was taken to the investigation office. Later, police officers took her and a colleague for questioning following a report of fraud, but denies any knowledge of what transpired at the station, but admitted that the claimant was charged to court for an alleged crime. However, GW1 admitted during cross-examination that there was no evidence that the claimant's profile was used for fraud. The defendant stated that the claimant's employment was rightly terminated in line with the staff handbook with a notice on the 19th of November 2013, which was to commence with immediate effect. And by a follow-up letter on 18th of April 2017, UBA stated that the payment in lieu of notice would be made, that the claimant's basic salary in 2012 was 54,529, and in 2013, from January, the basic salary became 74,378.93 kobo. UBA also admitted that although it had an upward review of its salary, it was not a right but a privilege earned through hard work. That the disciplinary committee invited the claimant for a meeting, but she failed to honor the invitation. The defendant also tendered the following documents, same were admitted and marked as SB D2 to D4. In the body of the judgment, I have the defendant's final written address and also the claimant's final written address. So I'll go straight to the decision of the court. Now, there were some preliminary issues. The claimant counsel challenged the admissibility of D3 and D4, which were the statements of account, that they should be expunged for non-compliance with Section 97 sub 2 sub E of the evidence, and this court shall rely wholly on the provisions of Section 12 of the National Industrial Court Act, which provides that for the interest of justice, the rules of evidence may not be complied with. In EFA versus ITA citation provided, the court held that civil cases are decided on the preponderance of evidence and not on the overwhelming final addresses of counsel, which cannot take the place of pleading and evidence. The implication of abandoning an objection in the final address is that the court will treat the evidence as unchallenged or admitted without contest and typically result in the waiver of that objection. If an objection was raised during trial but not pursued or argued in the final address, the court may deem the point waived. If a party chooses to abandon a specific objection or the entire address, they cannot later claim of a breach of fair hearing on that ground. Objections to Exhibit C4, C4, C5, and C6 are deemed abandoned and the documents are admitted. That is for the second objection. Now to the court's decision. It is strict law that for an employee alleging wrongful termination and unfair hearing in Nigeria, the onus of proving wrongful termination lies squarely on the employee, who must plead and prove the terms and conditions of their employment, how the terms were breached by the employer, and that the termination was indeed wrongful. This principle has been consistently upheld in various judicial pronouncements, including the cases of ABU Zaria and Idenyin, Ovive and Delta State Company Limited, Ahmed and Federal Civil Service Commission, Akpabio and Union Bank, citations all provided. These cases emphasize that failure to adequately plead and prove these elements can be fatal to the employee's claim. Similarly, for an unfair hearing claim, the employee must demonstrate a breach of the principles of natural justice or the employer's internal disciplinary procedures. The claimant before this court is seeking a declaration that the termination of the claimant from employment without fair hearing and without regard to the procedure in the staff manual or handbook is wrongful. Claimant has based the claim for wrongful termination on the lack of two ingredients. One is alleged lack of fair hearing, and two, failure to follow the procedure in the handbook. With regards to fair hearing, the National Defense Counsel argued in its final written address that these issues did not arise as the claimant only exercised its right to terminate so long as the relevant notice of payment in lieu of notice was given. Besides, the letter made no mention of termination for fraudulent activities, and by claimant's failure to attend the disciplinary committee's meeting, there was no decision to that effect or conclusion. Claimant, on the other hand, maintained during trial that she did not receive the invite to a disciplinary hearing during the bail period and did not appear before any. The disciplinary committee she met with on the 2nd of September 2013 failed to properly investigate the allegation, did not allow her to defend herself, and merely handed her over to the police without evidence for the fraud that never took place. While she was arraigned at the magistrate court on the 6th day of September 2013, and her employment was terminated on the 26th of November 2013 with immediate effect. This took place without 1 month notice, therefore the termination was wrongful. This court noted that parties are in agreement on all facts related to the claimant's arrival at headquarters and the interaction with the 3 men in the investigation room and subsequent arrest by police officers. Claimant has maintained that she was never invited to a hearing after she was granted bail. This was reported by the defendant, who claimed that the claimant failed to honor the invitation. This invitation was not exhibited to the court throughout trial. Whether it was by email, text, or later, the court was never informed. In the circumstance, this court finds that the claimant was never invited to appear before an investigation panel. What the claimant appeared before was the 3-man investigation panel on the 2nd of September 2013, and by paragraph 3 of the defendant's statement of fact, UBA admitted to what claimant had averred in a paragraph 6 to 12 and 14 of a statement of fact. The principle of fair hearing, a cornerstone of natural justice, dictates that an employee must be given an opportunity to know the allegations against them and to defend themselves before any adverse action, such as termination, is taken. This requirement for a fair hearing is deeply entrenched and mandates that an employer must adhere to certain procedural steps before terminating an employee for disciplinary reasons. These steps typically include issuance of a query. This must be clear and detailed enough for the employee to understand the case they need to answer. The employee must be given a reasonable opportunity to respond to the query, explain their actions, or present their defense, typically in writing. This will lead to a hearing at a disciplinary panel/committee, where the employee should be allowed to present their case, call witnesses if applicable, and cross-examine adverse witnesses. While the Labour Act Section 11 allows for termination of contracts by notice without necessarily stating a reason, this typically applies to simple termination and not to dismissal for misconduct. Where misconduct is alleged, the employer's actions are scrutinized under the lens of fair hearing. Otherwise, the termination is likely to be deemed wrongful. See Azave versus First Bank Nigeria, Mortgages Limited, and Damabara versus AG of the Federation. which reinforces the necessity of trying and finding an employee guilty of misconduct through a proper process before termination. Also, the case of First Bank of Nigeria versus Akanji citation provided clarified that querying an employee and receiving an answer can satisfy the requirements of fair hearing, provided the process was thorough and the employee had a real opportunity to defend themselves. However, this does not negate the need for a formal hearing in more complex cases or where the employment contract or staff handbook mandates it. This is the position of the law with regards to termination due to misconduct. Having said all this court took a critical look at the termination letter and noted that the letter of termination, Exhibit C6 of November 19, 2013, reads thus, and I quote, "This is to advise that your appointment with the bank has been terminated with immediate effect for service no longer required." It is without doubt that this termination made no reference to the alleged fraud that led to the claimant's arrest and trial at the magistrate court. The defendant shrewdly couched the termination letter to reflect the fact that the claimant's services were no longer required, and in such situation, all the court is saddled to determine is whether the process for termination was rightly followed. This is the finding of the court. Now, for the claimant to succeed in the claim for declaration, it is tried that one fundamental and most distinguishing feature of a declaratory action is that it is never granted merely as a matter of course. That is, the plaintiff or claimant is under a duty to succeed on the strength of his case and not merely on the weakness of the defense. This is because a court is devoid of the judicial competence to grant declaratory reliefs, either in default of defense or on sheer admission devoid of credible evidence. Put differently, a declaratory relief cannot be granted without recourse to evidence. See Aminu and Suberu, citation provided. To prove a case, claimant pleaded and exhibited the offer letter dated the 25th day of August 2007, marked as Exhibit C4, paragraph 8, provides thus, and I read, "Notice. After confirmation of employment, UBA services shall at all times give 1 month's notice except in the event of dismissal for gross negligence or fraud. To demonstrate the employer failed to follow established procedure for disciplinary action or termination and deviated from its own rules which constitute wrongful termination, the claimant tendered the defendant's staff handbook marked as Exhibit D1 that shows the procedure for termination. Page 64, Article 9.4.1 and Article 9.4.2 reproduced here for ease of reference reads, and I quote, "Termination. UBA Group may terminate the employment of an employee when applicable with termination notice. When applicable with termination notice given as defined under resignation above." 9.4.2 reads, "An employee whose employment has been terminated shall be entitled to receive benefits determined in line with the compensation policy." Her case is that on the 2nd of September 2013, she arrived at headquarters and was taken to investigation room where she was seated before 3 men and asked what she knew about the matter, in quote, and she denied knowledge of any matter. Later, one Ojimi Olumide entered the room and she identified him as her colleague in the office. She was then given a sheet of paper to write a statement, and soon after, police officers arrested and took both of them to Ikoyi police station. They were charged to court on the 6th of September, and on the 19th of November, she received the termination letter, Exhibit C5. The stated reason was, and I quote, for service no longer required," end of quotation, "with immediate effect, and that your terminal position with the bank will be communicated in due course." Another letter of termination was issued after about 3 years, 3 years, that was on the 18th of April 2017, with an attached schedule indicating her net benefit put at 145,509.76 kobo. The point to note here is that Exhibit C4 provides for 1 month notice in case of termination, except in the event of dismissal for gross negligence or fraud. This court had earlier found that the claimant was not dismissed. The reason was not for negligence or fraud. What we have before the court is a case of termination for services no longer needed. The question now is, did the defendant provide 1 month notice before termination? Parties are in agreement that the termination letter was issued on 19th of November 2013 and payments were made as exhibited in a statement of account of 1st March 2017 to 30th April 2017. Did the defendant comply with the procedure for termination? Parties are equally in agreement that a letter of termination was issued to take immediate effect That's paragraph 14 of the statement of defense. And a follow-up letter of termination was again issued on the 18th of April 2017. That's paragraph 15 of the statement of defense. Attached was a breakdown of a benefits, that is payment in lieu of notice and other benefits paid between the 1st day of March 2017 to the 30th day of April 2017. This payment was exhibited in Exhibit D3. The position of the law regarding the termination of an employment contract, particularly when it involves a specific notice period and payment in lieu, is well established in Nigerian labor jurisprudence. The core principle is that a contract of employment can be terminated by either party giving the agreed notice or by paying salary in lieu of such notice. However, the timing of this payment in lieu is a critical factor that can affect the validity and effectiveness of the termination. The general principles of termination by notice and payment in lieu is governed by Section 11 sub 1 of the Labour Act, which provides that either party to a contract of employment may terminate the contract on the expiration of notice given to the other party. While the Act provides for notice, it is a common contractual term for parties to agree on payment in lieu of notice. This means that instead of serving the notice period, the terminating party can pay the other party the remuneration that would have been earned during that notice period. This practice is legally recognized as affirmed in the case like First Bank of Nigeria, Merchant Bank Limited versus Owotemu citation provided, which confirms that a contract of employment can be validly terminated, validly determined by the employee making payment in lieu of notice and by extension, the employer. That being said, another critical aspect of this principle is the timing for payment in lieu. Nigerian courts have consistently held that for a termination by payment in lieu of notice to be effective, the payment must be made either contemporaneously with the letter of termination or at the very least before or at the point of the employee ceasing to work. The rationale behind this is that the payment in lieu is a substitute for the notice period itself, and therefore it must accompany the act of termination to make it complete and effective. The Court of Appeal in Ikemba versus Pyramid Company Nigeria Limited citation provided addressed this directly. The court held that the failure to issue a letter of termination of employment contemporaneously with a salary in lieu of notice will render the termination of employment ineffective. This implies that the payment in lieu should ideally be made at the same time the termination is communicated, or at least not significantly delayed. Even more pointedly, the case of Mainstream Bank Registrars Limited versus Olugbenga citations also provided dealt with the effect of salary in lieu of notice made after the alleged termination. The court emphasized that payment in lieu of notice must be made at the time of termination. If the payment is made after the employee has already been told to stop working or after the termination letter has been issued without the accompanying payment, the termination may be deemed wrongful or ineffective from the date of the initial communication. The employee would then be entitled to their salary and benefits for the period between the purported termination and the actual date the payment in lieu was eventually made. The legal implication is that the termination may not have been properly effected at the initial date. The employee could argue that they were still in employment until the date the payment in lieu was actually received. This could entitle the employee to salaries and benefits for the intervening period. This is because without proper payment in lieu, the notice period was not effectively substituted and the contract was not validly determined until the payment was made. On this thorny issue, it is instructive to note the dictum of the learned jurist Helen Moren K.G. Ogunwumuji, Justice of the Supreme Court, in Sky Bank versus Adigun, and I quote, "Where parties to a contract mutually agree that the condition for termination of the appointment is the giving of notice or payment of salary equivalent in lieu of notice, the only valid notice to discharge a party from his obligation under the contract is the giving of the appropriate period of notice stipulated or the payment on the effective date of the notice of the salary or other prerequisites covering the period of notice in accordance with the contract of service." It should be stressed at this junction that the payment of the salary in lieu of notice should be made immediately the letter of termination is handed to the employee. Where the court finds out that the employee's employment was wrongly terminated, he will be entitled to the payment of his salary and other entitlements for the period for which the employee should have been given notice of termination as damages for the breach. See also Samson Babatunde Olarewaju versus Afribank PLC and Medigri Flour Limited versus Abba citations all provided. End of quotation. There is no doubt in the mind of this court, going by Exhibit C4 and D1, that the termination was without regard to the procedure in the staff handbook. Claimant employment was terminated on the 19th of November 2013, and payment in lieu of notice was paid on the 18th of April 2017. The relief sought for a declaration succeeds to the extent that the determination was regard to the procedure in the staff handbook I so hold. Relief 2 is for an order setting aside the termination for lack of fair hearing. This court had earlier found that the basis for the claimant's termination was for services no longer needed. It was not based on lack of negligence, misconduct, or fraud, of which fair hearing would have been a requirement. The legal implication of a court setting aside the termination is profound. In Nigerian labor jurisprudence, the act of setting aside is not merely a procedural correction, but a substantive reversal that restores the party to their previous position as though the act never occurred. In the case of Mutala versus INEC, the Court of Appeal, relying on Black Law's dictionary, defined set aside as, and I quote, to annul or vacate judgment or order. End of quotation. So in other words, to set aside the decision is to state that such a decision is not legally valid and the act becomes non-existent. According to the principle in Pity and Audu, citation provided, a decision or an act that is set aside is treated as if it never happened and the status quo ante is restored and the contract remains subsisting. See also ASO Savings Loans versus Iwunamara. Citations are all provided. For statutory employment, reinstatement is a powerful remedy setting aside a termination of often leads to an order of reinstatement and the payment of arrears of salaries because the legal foundation of the termination was void from the beginning and aimed at restoring the employee to their previous position or compensation or compensating them adequately for the wrongful dismissal. Reinstatement is not practicable, notably in master servant employment. The court may award damages in lieu of reinstatement, which would typically cover the period the employee would have remained in service along with other entitlements. The National Industrial Court, established under the National Industrial Court Act 2006, is empowered to grant various remedies including reinstatement, re-engagement, and compensation. See Section 7 Sub 1 Sub C of NICA 2006. The court's approach is often guided by principles of fairness and good conscience, aiming to do substantial justice between the parties. In the instant case, the claimant's employment fell within the ambit of the category where there is a written contract of employment between parties and the court has a duty to determine their rights under the written contract. The employment contract had no statutory flavor. Relief sought for reinstatement fails accordingly, I so hold. The third relief is for special damages in the sum of 5,466,300 in bracket or any upward review of salary, which includes all the areas of salaries, benefits, and allowances which the claimant is entitled to from the month of November 19, 2013, when the claimant's employment was wrongfully terminated till the day of judgment with interest. It must be noted that areas of salary, benefits, and allowances, aside from being a claim for special damages, which by UTC versus Samuel Peters, relying on Luke Onyora versus Benedict Onyora, and Okafor versus Obiwo, citations all provided, must not only be specifically pleaded, but must be strictly proved by credible evidence. And it's a relief that is tantamount for asking for reinstatement. The claim for special damages in labor relation must meet the twin requirements of proof as to entitlement and how the quantum of the sums claimed was arrived at. See Mr. Rufai versus Bureau of Public Enterprises, unreported suit number NICN LA 18 2013, the judgment which was delivered on the 4th of June 2018, and Mr. Dungus versus ENL Consortium, citations are all provided. There is little or no attempt by the claimant to meet these twin requirements in both his pleadings and deposition. Even when the defendant admitted that he increased the remuneration of his staff in paragraph 5 of his statement of defense in response to paragraph 15 of the claimant's statement of fact, the claimant's relief, being monetary in nature, should be specifically pleaded and strictly proved. In other words, items constituting the claim must be particularized in the pleading and proved by cogent evidence for easy ascertainment, qualification, and calculation of the sum claimed. See Ozigbo Engineering versus Iwu Amadi, citations all provided. Claimant tendered Exhibit C8, which was salary review / upgrade with effect from 27th of June 2008. Firstly, this upgrade was with effect from 1st of July 2008. The fact of this case was bettered in 2013, and the defendant's admission of an upward review was in September 2013. To the mind of this court, the claimant failed to provide evidence of this upward review in 2013, and and to direct the court to the particulars of the claim. In the circumstance, relief 3 fails, I so hold. Relief 4 is for general damages against the defendant in the sum of 15 million naira for the pain and suffering brought on the claimant following the wrongful termination of the claimant's employment by the defendant. On this particular claim, the defendant argued that the fact that the claimant acknowledged that salary in lieu of notice was paid and acknowledged the claimant cannot claim general damages. Yes, while an employer has the right to terminate an employee's contract, this right must be exercised in accordance with the agreed terms and relevant labor laws. It is right that when the termination is found to be wrongful, general damages in the termination case, even one based on services no longer needed, can be awarded. General damages are pecuniary losses that are presumed to flow naturally from the wrongful act without the need for specific proof of their quantum. They are awarded to compensate the claimant for the inconvenience, distress, loss of reputation, and other intangible losses suffered as a result of the wrongful termination. This is distinct from special damages, which are specific, quantifiable losses that must be pleaded and strictly proven, such as unpaid salaries, allowances, or benefits up to the date of termination or payment in lieu of notice. The Supreme Court and Court of Appeal have clarified this position in numerous cases. For instance, in Benway Breweries versus Okonta citation provided, the Court of Appeal considered whether general damages could be granted in an action for wrongful termination of employment. The principle established is that where a termination is found to be wrongful, the employee is entitled to damages. While the primary measure is often the notice period, general damages can be awarded to cover the non-pecuniary losses. Similarly, Talon Global Services versus Olali citation provided further elaborates on the measure of damages recoverable for wrongful termination, emphasizing that the court aims to put the employee in the position they would have been had the contract been lawfully terminated. Even if the employee's stated reason is services no longer needed, which often implies redundancy, the termination can still be wrongful if the employee fails to adhere to the contractual terms regarding notice, payment in lieu of notice as outlined in the contract. It is a law that failure to provide the stipulated notice or payment in lieu of notice, even for a termination based on services no longer needed, renders the termination wrongful and can attract damages. This court is not unmindful of the principle that once an employee collects terminal benefits, his employment is brought to an end. He cannot be held to complain later that his contract of employment was not properly determined because the acceptance of payment by the employee renders the determination mutual, as enunciated in the case of Julius Berger versus Nwago citation provided. In the instant case, the claimant was issued a termination letter on the 19th of November 2013, Exhibit C5. There was no payment in lieu of notice. More than 3 years later, the defendant decided to pay into the account domiciled in the defendant bank. Can this court deem such payment as proper determination of the employment? This court does not think so. This action falls under the ambit of an unfair labor practice which this court abhors. While there is no statutory definition of the concept of unfair labor practice in Nigeria, the term unfair labor practice, however, has been generally defined to mean practices that do not conform to best practice in labor cycles as may be enjoined by local and international experiences. See the case of Mrs. Olumagin and Total EP Nigeria Limited, suit number NICN LA 580 2018. Also see Mixed and Bake versus Nufti, an aluminium manufacturing company Nigeria Limited versus Volkswagen Nigeria Limited, First Bank of Nigeria versus Associated Motors, and MPWN versus Alzico Limited, and also Bimbo Atilola's Labor and Employment Law in Nigeria, a practical guide, volume 1, Lagos Hybrid Consult 2022, page 15. It is undisputed that unfair labor practices consist of acts or omissions in employment relationships that are considered unjust, inequitable, oppressive, and highly unconscionable, including grave breaches of employees' rights. By virtue of the power granted this court by Section 254 sub 1 sub F of the Constitution, Third Illustration Act, this court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters F relating to or connected with unfair labor practice or international best practices in labor, employment, and industrial relation matters. It is the intendment and basis of the expanded mandate of this court, courtesy of the extant constitutional provision, to deal with issues of unfair labor practice, best practices of labor relations, and codified/uncodified international best practices and policy issues in labor and employment matters. See Section 254 sub 1 sub F sub H of the Constitution. as amended by the Third Culturation Act 2010, effective March 4, 2011. I have reviewed the facts and the circumstances of this instant case, and I find that the payment of salary in lieu, which UBA made after more than 3 years, is an unfair labor practice. For a staff that worked consistently in an organization unblemished for about 6 years, that's 2007 to 2013, and was terminated with immediate effect for services no longer needed. Equally, I find that the claimant was never issued any query before the incident of the arrest on 2nd September 2013. There is undisputed evidence before the court that claimant appeared before a 3-man investigation committee and criminal proceedings were initiated against the claimant. Without proper investigation, she was handed over to the police and the termination was during the pendency of the trial, which eventually ended in a discharge and acquittal. All constitute aspects of unfair labor practice, which this court, riding on its mandate in Section 254 sub C, Section 254C sub 1 sub F of the Constitution, is poised to curtail whenever and howsoever it rears up in adjudication. Such an unfair labor practice is actionable and attracts award of damages to assuage the pains of the victimized staff. See also Leonard Oyibo versus Guinness Nigeria Limited, suit number LA NICN LA 639 2012, judgment delivered on September 20th, 2019 per Ogwaya J. Also, in Garba versus Governor of Kano State, citation provided, the court reiterated the measure of damages in a claim for wrongful dismissal, which often includes general damages for the manner of dismissal, especially if it caused undue hardship or reputational damage. The law recognizes that where an employer acts maliciously, oppressively, or in bad faith towards an employee, he is entitled to damages beyond mere salary in lieu of notice. See British Airways versus Makonjuala, citations also provided. The court's discretion in awarding general damages is guided by the specific facts and circumstances of each case, including the nature of the employment, the manner of termination, and the impact on the employee. The courts have enjoined employers to ensure that when opting for payment in lieu of notice, the payment is made concurrently with the communication of termination. This ensures that the termination is legally effective from the intended date. It is tried that when termination is effected, there should be no delay in payment. This could constitute a breach of the contractual terms regarding termination, potentially leading to a claim for damages, especially if the delay caused hardship or further loss to the employee. The NICN has further held that conduct exposing an employee to humiliation, psychological trauma, and financial hardship attracts aggravated damages. See Afolaya versus University of Lagos, citation provided. Given the length of the criminal trial, the emotional and financial distress suffered during the period of receipt of the termination letter and the late payment of salary in lieu, including termination in the course of the trial and the eventual collapse of the criminal case, this court is satisfied that the defendant's conduct was high-handed and oppressive. Let it be known loud and clear that this court, in evaluating the facts and the evidence set before it, made no finding that the termination was based on fraud or misconduct. Exhibit C4 clearly stated the termination was with immediate effect for services no longer required. Now, irrespective of the employer's common law right to hire and fire for any or no reason, the NICN currently recognizes that globally, it is no longer fashionable in industrial relations law and practice to terminate an employment relationship without adducing any valid reason for such a termination. And within the banking sector, the NICN also recognizes that termination of an employee's employment with immediate effect suggests some wrongdoing on the part of the employee, which the employer must justify if the employer is not to be saddled with more than 1 month's pay in lieu of notice. However, I need to make a point here. Given that the NICN is empowered to apply international best practice by virtue of Section 7 sub C of the NIC Act 206 and Section 254C sub 1 F and H and sub 2 of the 1999 Constitution, this court has relied on the ILO Termination of Employment Convention 1982 number 158 in submitting that termination of employment must today be for just cause. In some decisions of the NICN, this submission has been accepted and Convention number 154 was applied, as was the case in Bello Ibrahim versus EcoBank PLC, unrepeated suit number NICN ABJ/144/2018, the judgment of which was delivered on the 17th day of December 2019. Furthermore, Section 15 of the Labour Act, though primarily dealing with periodicity of regular wages, underscores the general expectation of timely payment of entitlement. It is right that general damages are awardable per se upon breach and is compensatory in nature in monetary form, as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party by the act of the breach of the contract or injury inflicted and for acts constituting unfair labour practice occasioned by the defendant. Accordingly, relief succeeds to the extent that the sum of 10 million naira is hereby awarded against the defendant in favour of the claimant as general damages for the pain and suffering brought on the claimant following the wrongful termination of the claimant's employment by the defendant. The cost of this suit is assessed at 500,000 naira only. All sums awarded in this judgment shall be paid within 30 days from the date of delivery of this judgment, failure which the sum shall attract simple interest at the rate of 10% per annum until fully liquidated. Judgment is accordingly entered. This is the judgment of the court.
As my Lord pleases, we sincerely appreciate the wisdom of my Lord in delivering such a detailed judgment. We pray that may God Almighty continue to strengthen me, Lord, and empower me, Lord, with more wisdom so as to dispense justice that people will see, not only heard of. We are so grateful, my Lord.
My Lord, we are grateful for the well-considered ruling.
It appears that my Lord is not on the line. Moderator, please, can you hear me? Moderator. Hello? Moderator, please, can you hear me?
I think it's safe to log out.
To log out. All right. Thank you very much.
Thank you, Counsel.